Okay, this is a good one. I mean, it's a rarity that some parents, when they're acting pro se, which means that you're acting as your own attorney, which under special education law you can do that. You don't have to go out and get a specialized attorney like me. You can, but depending on the state you live in, attorneys do things differently, which they have every right to with regards to how they run their business. Um, I would like to say that the Galini group is a little bit different in how we approach special education law, and then how we also represent clients so that our services are accessible to all families, regardless of income. All right. So, but that's how we've chosen to do our business model. Um, but in other states, they don't. And because of that, it puts parents in a financial straits because a lot of these attorneys just will not um, front their time, I guess you could say, and treat it more like a contingency case, like a damages case, which, the different models, different people, different states. And, there tends to be sort of an embedded or an established culture with regards to how the other attorneys do it, because the existing attorneys that have been doing it a while, anytime somebody else comes in, that's just sort of the culture. And because special education is a small um, group of attorneys in every state, because it's a very small field, then it becomes extremely difficult in some of these states to break that cultural cycle, because the board attorneys become extremely adversarial and extremely aggressive when somebody comes in and tries to upset the apple cart. And we are experiencing that, my firm, because we've been moving into states, and some states, it's similar to the culture that we have in other um, states where we practice, but in a few, we're upsetting the apple cart, and they don't like it. And so, unfortunately, this is a 50-50 kind of negotiating process. Otherwise, you find yourself in due process a lot. Why? Because people don't like to change. Government doesn't like to change. Humans don't like to change. I don't care how much they say they want change, but they don't like change. People don't like change. And so uh, the way that my firm does things in certain areas is a change in some of these states. So when parents are left with very few options, for various reasons, then they can act as their own attorney. They can act pro se, and in that regard, it doesn't mean that you can't do it. I mean, I know it seems daunting, and it is. I mean, I can't lie to you. When I first started doing this, believe me, it was, a new experience for me. It was terrifying. My first case was my child. So it's not like I haven't been there personally, to where, even though I was an attorney, uh, my wife and I were acting pro se, because I'm not treated the same way when I'm acting as a capacity of parent for my own child. So I have been there. Okay, so parents can do this, but what we're trying to do is, my firm is trying to create um, a series of instructional videos that would be available for parents to be able to access, walking them through in, I don't know, a 30-minute or an hour increments, each step of due process, including how to analyze the case, how to spot the issues that the hearing officers or the administrative law judges care about, because that's one of those nuances that many, many parents don't understand. And if they don't understand those nuances, then they tend to argue emotion. And emotion is a bad thing to argue in special education law. because the law is not emotional. The law just is. And so therefore you've got to understand how to spot the issues that are attached to a free and appropriate public education. And that includes educational performance. That includes data collection. That includes all of those things in order to establish, because in most states in this country, the parent has the burden of proof. Quite frankly, I don't agree with that. I think the school should have the burden of proof because they're the ones responsible to provide a FAPE. So therefore, they should have to prove that they did in fact provide a FAPE. But that's not the world we live in. In most of the states, the parent has to prove that the school didn't do their job, which sometimes gets extremely difficult. So that's why somebody like me, has a big value when you're trying to do that, because we do have an expertise of being able to spot those issues and being able to separate the emotion, which is very difficult to do when you are advocating for your own child and your child's been damaged by this process. So in that regard, once you go through due process and there's a decision rendered, then you can appeal it to federal court. Which is what is called a de novo review. And the reason it's called a de novo review, which is Latin, it basically means a first look, but at the same time, it's still an appeal. The reason being is that the hearing officer, the administrative law judge, is a gatherer of the facts, the trier of fact, meaning that they're taking the testimony and they're taking the school record of the evidence, and then they're making a decision based upon that. Hearing officers and administrative law judges cannot make determinations of law. Okay, they can make determinations of fact. But at that point, because they cannot make determinations of law, and let's say after your decision, you're not happy with the decision or the school's not happy with the decision, they can appeal it to the federal court. And at that point, that's why it's called a de novo review. You get the appeal on the facts. But at the same time, you get a first review when it comes to issues of law. And that's why it's sort of bifurcated, if you want to say that, to where there's two different duties of the federal judge. But it does go to a federal judge, sometimes a federal magistrate, which is sort of right here beneath a federal judge. But at the same time, now you're getting into the federal rules of civil procedure, and those are extremely tight, and they're unforgiving, and that's just how it works. Now, at the same time, what you're saying in your question is that you're treated to a different standard than the board attorney in your viewpoint. And at that point, you don't understand why. Well, if that is the case, I can tell you that life isn't fair. And these judges, unfortunately, and especially I think in our world today, because they're appointed by whatever administration has to be or happens to be in power at the time. And because we have such a growing divide between the two political ideologies in this country, then at that point, depending on who the president was at the time that appointed your particular federal judge, you may have somebody that was selected that has very deep-seated ideological beliefs. And in my experience, in our experience, in dealing with federal court, I can tell you that I would much rather have, depending on the issues, okay? So it's all an issue thing. But I can tell you that I get much better results out of conservative judges than I do liberal judges. Now, why is that? I don't know. The only thing I can think, or the only thing is that conservative judges tend to be a little bit more inflexible with regards to what the law says that a school must do. And in that capacity, there's not a lot of flexibility with regards to the excuses. And in those capacities, especially in the states where we practice, um, we've gotten better results out of the conservative judges, depending on what the issue is, because in sort of conservative mindset, rules are rules are rules, and you need to follow those. With some of the liberal federal judges that we've gotten, um, there tends to be a little bit more forgiveness and flexibility given to the institution, the government institution that is there to help. And the mindset is, well, they're there to help. And we don't want to take away education dollars when the intent is to help. And so they tend to look at parent attorneys as sometimes trying to take away from the school resources. So of course the board attorney argues that all day long, that the parent is trying to take away from limited school resources that could be used for other children. And believe me, it's a strategy. How you argue depends on who the judge is. And you need to do some background on the philosophical beliefs of the judges. It's not hard to do. You read their prior cases, or you understand their prior history with regards to their track record before being appointed to the federal court. You also do that with your hearing officers and your administrative law judge. You need to sort of get into their mindset. How do they look at this? How have they ruled in the past? Because it's very important to understanding how you need to present your information. Because once again, you're talking to human beings, and those human beings come with their reinforcements themselves on their own environment, how they were raised, their beliefs, be it political, be it religious, be it scientific, it just doesn't matter. All of those things create a human, and humans, most of us, have tunnel vision. And the older we get real narrow with regards to our tunnel vision, because we have reinforced experience in our lives. And those reinforced experiences, be them good or bad, help shape our opinions. And that's why typically the older people get, the more conservative they get, because of those experiences. And so, all of those things, all of those nuances. And so is the process fair? No process is fair. It's intended to be fair, but intention paves the way to hell. Okay, good intentions, that's government in a nutshell. But in application, that's just not the reality. So yes, it's not fair, and you could focus on the fact that the judge is treating you by a different standard, but that isn't going to get you anywhere. It is what it is, what it is. All you need to do is ensure that you are objecting where you need to object, because that becomes a potential appealable issue if you need to take it to your appellate court. That next step, which is the step right before the Supreme Court, but that's what you would need to do. But at the same time, you got to walk a fine line, because you very well could be upsetting your federal judge by accusing the federal judge of showing favoritism. So there is a fine line in how you do that. But, in some instances, you do need to preserve these appealable issues by raising them in your responses, that, you're following the rules, the board attorney is not. And, so therefore what that does is that disenfranchises you, or creates an issue of inequity in the consideration or the process. And that potentially could be an appealable issue for you. But other than that, you just need to follow the rules. And yes, it is far more difficult pro se. Hell, I've got a very, very good appellate attorney that used to do a lot of appeals work prior to switching into special education law. And so she handles all of the fine nuances in the rules with regards to all of our federal filings. And she does an excellent job. But I can tell you, it is time consuming. It is taxing on our side even to make sure that we do it right, to make sure we follow the rules. I cannot concentrate on what the other side is doing, because what it does is it takes the emotion and it takes the focus off of the issues and off of what I need to do. And believe me, sometimes it's a strategy by the opposition, by the other law firm, to try to take you off your game, to try to take the focus off of the issues in order for them to gain advantage over you, because they have no argument, and those become strategies. So sometimes you need to think about that.